Hello, everyone. I am thrilled you can join us today. My name is Brad Weltman, and I am with Facebook and based in Washington, D.C. I am honored to be the moderator of this panel today, and it's wonderful to have such a global audience because we have a world-class collection of experts assembled on this panel on online advertising. Our topic today is just that, online advertising. So you will hear from experts from India and Russia and Turkey and Germany and Venezuela who'll share insights from their home countries as well as some insights into advertising related trends in their regions. We've structured our webinar today so that we'll have time to hear from each of the experts individually and then have an opportunity for a group conversation so they can react to what their colleagues have said and give some shared ideas and advice in a broader webinar format. Please feel free to use the interactive tools to ask questions. I will do my best to integrate them into the conversation, and we want to make sure that we're making this the most useful for you and useful as it can be. So with no further ado, please let me introduce our panelists today. First up is Hande Hanser, who is based in Turkey. She is a partner in the firm of Gunn & Partners and is co-chair of the firm's intellectual property and technology, media and telecommunication practices. In addition to her work on intellectual property matters, Hande provides support to clients on consumer law, particularly for labeling and product liability issues, commercial communication and advertising, data protection, ensuring that their products and services are compliant with the Turkish regulatory regime. Next up, welcome, Hande. Next up is Canoe Priya, who joins us from India and is a partner at Khan & Krishmi and has extensive experience advising clients on a wide variety of advertising, media and marketing laws, other related matters, including sweepstakes and promotions and contests. She also counsels clients on the right of privacy and publicity, telemarketing, direct mail, email marketing, and copyright matters, and actively engages the government and patent offices in policy formulations. Welcome, Canoe.
Thank you.
Maria Ostashenko is from Russia and a partner at ALRUD law firm, heading commercial, intellectual property, and data protection and cybersecurity practice areas. Maria supports Russian and foreign clients, providing her expertise in areas including pharmaceuticals and healthcare. We'll definitely dig into that. FMCG, banks and financial institutions, retail trade, telecommunications, media, and technology. Welcome, Maria.
Thank you, and hello.
Soren is based in Hamburg, Germany, and is a partner at Hooking, where he is in charge of the intellectual property and advertising law department. He is also a member of their data protection task force. Soren writes and lectures on advertising law, unfair competition law, as well as on intellectual property issues such as trademark law. He focuses on advising clients in the manufacturing industry, as well as in the service industry, including advertising agencies on all aspects of advertising law. Soren also clears ad campaigns and sweepstake rules for a national agency and does transactional work in international intellectual property matters. As far as data protection is concerned, he advises clients in data protection issues, especially around the user interface on the internet. Welcome, Soren.
Thank you. Hello.
Finally, Ricardo Antequera from Venezuela is the firm's managing partner and has more than 25 years of experience in the field of intellectual property, entertainment, and advertising law. He has provided advice and developed strategies for transactions and litigation related to trademarks, copyright, unfair competition, advertising, data protection, privacy, and entertainment. He is a mediator and arbiter for the Arbitration Center of the Chamber of Commerce of Caracas and also for the Brazilian Center of Conciliation and Arbitration. Welcome, Ricardo.
Thank you, Brett.
We drew straws to see who is going to go first today, and Hande was the lucky winner. So I will invite Hande up to our virtual stage, and let's get started with you. So thank you, Hande.
Thank you very much, Brett. Yes, I will first talk about Turkey. Thank you very much for all people who joined us today. Well, in Turkey, actually, there are no specific laws relating to online advertising. So the general rules about offline advertising are applied, and the market is supervised, monitored in general by the Advertisement Board, which is a regulatory body established under the Ministry of Trade. So the general rules about advertisement, like the honesty, accuracy, and other types of the rules, which we all know very well, are also applied to online advertisements. And also the forbidden category, which are the tobacco products, alcohol products, drugs, pharmaceuticals, and gamblings. The rules about this forbidden category are also applied in online media. Likewise, the strict regulations about children advertisements or the advertisements related to children items, and the stricter rules about health claim advertisements are also applied in this online media. Influencer marketing is another and most used form of online advertisement in Turkey, like I believe this is the case for other countries as well. Here, we also do not have any specific regulation or guidelines about this influencer marketing, but what we usually see is the rules about hidden advertisements or the testimonial advertisements are applied here. Well, in general, I can say that the rules about advertisements are applied in a less stricter manner when it comes to online media. So, for instance, the rules about public order or public morality, which are all very important principles actually for Turkey, are applied in a more flexible manner. For instance, an advertisement including a couple kissing each other would be tolerated in an online media, while it would not be allowed most probably in a TV or any offline media. So in general, I can say that the rules are applied in a much more flexible manner in the online media in Turkey, but there is an exception for this, which is for health claimed advertisements. Last year, of course, and obviously because of this COVID-19 pandemic crisis, the regulatory body, the Advertisement Board, conducted quite strict comprehensive investigations and quite strict supervision on online media regarding the products advertised with health claims, for instance, food supplements or other products. Of course, this was related with this unique situation because of this pandemic crisis, but in the past also, health claims are quite important for Advertisement Board, so they are usually applying the rules very strictly in this when it comes to health claim advertisements. Last year, many influencers actually advertise some food supplements on their social media accounts, and they claim that these products are good for their immunity system and it helps them from protecting this coronavirus. And actually, Advertisement Board for the first time imposed monetary fines also on the influencers, not only the advertisers. So I think this also shows how these health claimed advertisements are important for Ministry of Trade. So briefly, actually, for Turkey, we do not have any specific rules for online media, and the rules are mostly applied in a much more flexible and a much more softer manner, except health claims. So this is actually basically what I can say about Turkey.
That was a fantastic start. Thank you. I have a few questions that I wanted to ask, but before I get to them, one question that I want to ask based on what you said. So I think it's interesting that there's a different, a different sort of set of standards for online and offline. The example you gave being indicative. As we think about the future of online advertising and online advertising regulation, do you think there's anything that may change that dynamic? Is there any effort afoot to increase the regulation of online advertising to make it either more consistent with the offline regime or for any other reason?
Yeah, actually, currently, we don't expect any new regulation from the ministry. But the reason why this online media is much more flexible, it is because social media users, they are using these platforms by their own will. Actually, it's not TV and children, and usually children are not very much involved in social media, or at least according to ministry. Of course, the children are quite involved in social media as well, but at least the ministry thinks the opposite, and this is why actually they are just leaving this online media much more flexible. But with the increase of this influencer marketing, actually there are some issues which are considered. One is the tax issue, actually, because how they can impose taxes on these influencers for their income. Of course, they gain because of these advertisements, and this is one aspect. But on the other hand, as I said, these health claims or health claimed advertisements or any other, because of due to the lack of any guidance about this influencer marketing, because they are not required to use this disclosure, etc. Normally, because of the hidden advertisement restriction, they have to, but as there is no clear guidance, this is a gray area. So some of them use, some of them they don't use, because there is not a specific regulation. So we may expect some new regulation in that regard, but other than that, I think the online media would be in this, softer, in this flexible way for some time in the future as well.
Great, thank you. Those are exactly the sort of useful nuggets I want to try to pull out of this conversation for the audience. So as they think about their spend globally, and as they think about doing business globally, we can give them that kind of guidance. So that's wonderful. I will say, in our pre-prep, the topic of influencer marketing was one thread that ran through everybody's notes and comments in our conversation. So I will definitely make sure that I spend some time on that in the end. Hande, one of the questions that I've teed up for everybody relates to self-regulation. IAA is a strong supporter of self-regulation, and so could you give us sort of the highlights of what the self-regulatory system in Turkey looks like, and maybe a little insight into the future of it, or one other interesting little nugget that we can take away?
Yes, actually, we have a self-regulation system in Turkey. Actually, we also have a self-regulatory body in Turkey, which is called Advertisement Self-Regulatory Board. Sorry. So this is a sort of NGO, actually, established by advertisers and advertising agencies and some media companies. So this board set some industry standards that should be obeyed, which are in compliance with the general advertising rules. Actually, they are also following the rules of the European associations about advertisement as well. So this board is helping people to clear their advertisements before they go on air, and people can apply to this board to get their clearance, or in some occasions, advertisers or companies use this board to file complaints against their competitors before escalating the issue before the Ministry of Trade, actually, before the regulatory body, because this board only gives some advisory decisions. So if the board will say that this advertisement is not compliant with the advertising rules, they are not entitled to impose any sanctions. They only give this advisory note so that the companies may review their advertising before they go on air, or if the competitors like a softer approach against their competitors, they apply to this board and get their advice before going to the administrative body, which would eventually impose sanctions, or before going to court. But I must say that Turkish people, they don't like this self-regulatory issues. Actually, they want to push the limits, and even if they would take an advice which they would not like, they would like to push the limits and see if there will be a sanction or not. So sanction is really is important for Turkish people, let's say. But in practice, we see that this board, this self-regulatory board, is mostly used by the Turkish branch of global companies. They usually use these boards either to take advice before they take a clearance before they go in the air, or they use this to file a complaint against their competitors, and to amically solve the dispute between them. So this regulatory board has been founded like 10 years ago, and it is commonly used. But like I said, mostly the branch offices of global international companies use this. This is what can I say about self-regulation in Turkey.
Excellent. Thank you. That was really useful. A very interesting insight. Particularly noted the point about Turkish people wanting to push the boundaries a little bit, which is why we have self-regulation.
Yes.
Lots more I should ask, but I want to make sure that I kind of get through the opening remarks for everybody. So let me invite Canoe to sort of the hot seat now. Canoe, and if you want to join and start sort of in the same fashion with sort of the overview of what may be happening in the India market, and then I have a few burning questions here for you to follow up, and I'll also react to what you say in real time. So welcome.
Thank you, Brad, and thank you everyone for joining us. I'm going to focus on regulation of online advertising in India. In the last couple of years, there have been quite a few developments concerning regulation of advertisements on social media and digital platforms. One of the most noteworthy development is the enforcement of Consumer Protection Act 2019, which was enforced with effect from 20th July 2020. This act has repealed the previous act, which had been in effect since 1986. And in fact, this is the very first act which talks about online advertising. In the definition of the advertisement itself, there is a reference of online advertisements, that is the advertisements which are made by means of electronic media or internet or website. So this is the very first time that any statute is covering online advertisement. And this act actually gives some idea about what kind of advertisements are prohibited in India. For example, the advertisements which falsely describes product or services, or which gives false guarantees or is likely to mislead the consumers as to the nature, substance, quantity or quality of product or services, or which conveys an express or implied representation which would constitute as unfair trade practice, or the kind of advertisement which deliberately conceals important information. For example, the information like commercial nature of the post. So these are the kind of advertisements which are prohibited under the Consumer Protection Act 2019. This act has also enhanced the scope of the unfair trade practice, which now includes within its ambit publication of any online advertisement for the sale or supply at a bargain price when that sale or supply is not actually intended to be at bargain price. So those kind of unfair trade practices have been specifically identified in the act. And a central consumer protection authority has also been established under the act with effect from 24th of July 2020. This authority is conducting investigations, instituting complaints, and ordering discontinuation of unfair trade practices and misleading advertisements. And the authority can also impose penalties on manufacturers, endorsers, and publishers of the misleading advertisements. The Central Authority has recently issued an advisory on misleading advertisements related to COVID-19, wherein they have cautioned against taking advantage of this ongoing pandemic situation in India. And they have said that do not make any claims without having any scientific credibility. For example, there are many claims which are being made in the advertisements, such as the product boosts immunity, or that it kills 99.99% of germs, or that it protects from COVID-19. So those kind of claims cannot be made, not unless there is actually scientific credibility or there's scientific data behind it, which can support the claim. And the authority is also, has also referred to the law the law under the Consumer Protection Act. They have said that resorting to misleading or false or deceptive advertisement is an unfair trade practice and is an immediate concern of law, and anyone violating the law will be liable to be proceeded against with imprisonment or fine. So uh, also under the act, an additional onus has been placed on the endorsers in addition to manufacturers and service providers. The endorsers are also responsible for preventing false and misleading advertisements. They have to verify the veracity of the claims which is being used in the advertisements. So they have to conduct their own due diligence. And the central authority, they may impose penalty on endorsers as well, in addition to manufacturers and uh, and the publishers. So also the endorsers may be prohibited from making an endorsement for a particular time frame. For example, for a period of 1 year if it's a first offense, or if for the subsequent contravention, they may be prohibited from making any endorsement for a period of 3 years. So up to 3 years. So these kind of sanctions, they're also defined in the new act. And apart from the Consumer Protection Act and other, legislation, there's self-regulation in India as well. Self-regulation is very important. So I guess I'll come back to that once Brad wants to ask me that question. I think Brad has planned that question for me.
Yeah, no, I am. If you want to segue into it right now, that would be fine. You set yourself up perfectly. I want to make sure that we get to the influencer advertising and digital media piece of it too, which I know is coming online. But you've set up my question perfectly. So yeah, I would be curious to have the sense of the self-regulatory environment in India.
Okay, so basically in India, there's a self-regulatory body, Advertising Standard Council of India, which is recognized by Supreme Court of India as well as other ministries and departments in India. In fact, there are regulations which refer to the Code for Self-Regulation, which has been adopted by the Advertising Standard Council of India. So basically, there are four principles which the Advertising Standard Council of India follows, and they are honest representation. That is, the advertisement should be truthful and honest to consumers and competitors. They should be non-offensive to public, as in they should be within the bounds of generally accepted standards of public decency and propriety. This is a very important point because India is a diverse country and there's so many cultures and and there's so many faiths, and everyone's language is different. So it's kind of very important that not to offend religious sentiments or or the sentiments of any community. So this is one of the principles which is most often used or applied. Then another principle is that the advertisement should not, should be against harmful products and situations. It should not be used indiscriminately for the promotion of products or which are hazardous to the society or to an individual, or in particular minors. And the advertisement should be, it should be fair in competition, and it should not be, it should not be derogatory. There should not be any plagiarism. Also, the Advertising Standard Council of India, the suo motu monitors the digital space. And since the onset of pandemic, they have screened more than 500 advertisements that had COVID-related misleading claims. They have also expanded ad monitoring to almost 3,000 digital platforms, and this is going to increase further in the future. Also, they have issued guidelines for influencer advertising. So, like you said, there's basically a guideline on influencer advertising. In India, of course, influencer marketing is, it's a hot topic right now because influencer marketing has increased to a great extent in India, and the most important concern as of now is that the influencers, they should not conceal the commercial nature of the post, and there's no other guidelines. As of now, there's a draft guideline which has been issued by the Advertising Standard Council of India, and but this is a draft guideline. It would be finalized by 31st March, and then it would be applicable for any post which is published on or after April 15th. So, so basically, one of the most important part of this draft guideline, which I found, was that they in this draft guideline they have specifically mentioned what are the disclosure levels that should be used in the post of the influencers. Like they have mentioned that what are the particular disclosure levels. For example, hashtag ad or hashtag promo sponsored. So these are the kind of labels that can be used. There are only 5 labels which can be used to show the commercial commercial nature of the post. That's
Yeah, that's wonderful. Thank you. I think that's, to me, that seems like a very relevant and important takeaway from the audience, given the importance of influencer marketing globally. Again, the top level story is regulation being finalized by the end of the month, comes online the middle of April 15th, and 5 terms that can be used to sort of denote that it's an influencer ad. So I think that's a really important takeaway. Thank you for that, Canoe. Maria, if we could invite you to share a little bit about the online advertising landscape in Russia, and then I'll follow up with some questions there. Welcome.
Yeah, thank you very much. Of course, like in Turkey, I think we have very similar situation. We don't have special regulation regarding online ads. So there are some general rules of our advertising law, and those general rules should be followed in every environment, including online environment. Regarding our regulator, we have Federal Anti-Monopoly Service, who is responsible for controlling the market, and they do investigations under the complaints of competitors or on their own initiative. And generally, they are the regulator who supervises the market and online advertising as well. Then we have also the consumer protection laws, and very often advertising law and consumer protection law intersect each other, and this leads to the authority of the Consumer Protection Authority to be involved sometimes and to be used by, for instance, competitors if they have complaints against some practices of the other competitor. So, but generally the regulator is the Federal Anti-Monopoly Service, of course. And then we have also quite a specific information legislation that contains some regulations regarding the content online. And the controlling authorities of different regulators. The main of those is so-called Roskomnadzor, which is, I think, difficult to pronounce for non-Russians, but it's the Russian Data Protection Authority. And here we have kind of intersection between advertising regulation and data protection regulation because of development of targeted advertising, and of course the data protection issues arise naturally. So that's the main framework, so to say, of the regulation in this field. We, of course, have specific protection of children, and we have specific laws on protection of children and rules regarding age rating, which I think is quite now often and widespread around the world. Also, need to mention that there is a draft law that introduces obligation to post social advertising. This bill was prepared and it's under consideration, so it's possible that it will be enacted, and then there will be some percentage that advertisers should distribute for social advertising. And regarding the products that are advertised, of course, we have priorities for tobacco, and we have general prohibition to advertise tobacco, including e-cigarettes. So last year we had a law that imposed prohibition for advertising electronic cigarettes as well, that led to even exit of some market players from the market. And due to the COVID, of course, the healthcare advertising and health claims were very important in terms of what was under attention of our regulator of the Federal Anti-Monopoly Service. There were several big investigations and complaints regarding different health claims made by different pharmaceutical companies. I think that's briefly it. I can say a couple of words regarding influencers if you wish, because of course their importance is growing, but we don't have special rules for them. And there was till this February, so till this year, there was no precedent where advertisers behind influencers were held liable for the actions of influencers. So it's very much different from what Hande said regarding the responsibility of influencers. So we had the opposite situation where influencers were held liable for their materials posted.
Interesting. Yeah, that. Thank you for sharing that. The influencers is definitely a hot topic. One of the I have asked everybody sort of the self-reg question, but one of the pieces that I found very interesting in what you shared me. So I may ask you a slightly different question. Was the FAS Russia, the anti-monopoly service, and some of what they found about unfair use of keyword targeting, and in a couple cases related to that, which I thought that was a very interesting, online topic. Is there a little more you could share with us about that?
Yeah, sure. Well, it's quite an old problem where using keywords in advertising was not considered as kind of unfair competition practice, and competitors could kind of buy keywords for promoting their brands using the brands of their competitors. Which some time ago finally was recognized as unfair competition. And it's more like IP and trademark related cases, because usually the brands that were used are protected by trademarks, and finally the Federal Anti-Monopoly Service found and came to the conclusion that using others' brands is not a fair competition. Well,
yeah, thank you. Good. No, I'm trying to pull out some of the useful nuggets for people who may be thinking about expanding into new markets or are already in markets, and just the watch outs of the online advertising world, I think is particularly useful from the audience. Who again, I would remind you, if you have questions, please use the channels. Hopefully you're watching on Facebook Live. I of course had to say that, but we love our friends at LinkedIn and YouTube as well. And so please, we happy to have your questions here. Maria, thank you very much. I appreciate it, and more to come in our group discussion. Soren, would love to hear from you about the environment in Germany, and then I've got my questions at the ready.
Yeah, thank you, Brad. Usually when I start talking about German law, I would say Germany is not for beginners. But while you would have expected that Germany has tough and comprehensive rules for advertising, for once, people may be disappointed. In this case, it's really simple. First, Germany has only one basic law, the Act Against Unfair Trade Practices, and a few regulations in specific fields. And second, the German legislator has entrusted the control and the enforcement of those rules, the advertising rules, almost completely to the market participants. And by that, I mean the competitors in the first place, and also the industry and consumer protection associations, privately run, including the chambers of commerce. And so far, there are no individual claims for consumers. So in my view, this could be considered the purest form of self-regulation. Very few exceptions apply in the fields to enforce advertising restrictions, such as the limitations concerning advertising for tobacco products, alcohol, especially pharmaceuticals, and gambling. but they are very limited restrictions only. And then we have a German Standards Advertising Council in Germany, who set standards for members only, but of course anyone can look at them and comply with them, but they are not binding for anyone except for the members, and only in this case only on a contractual basis. And beyond this, there's no regulatory power. They can just do name and shame, and they do. If something that is not regulated by the law, the Standards Council, they will name and shame you and make some remarks, maybe even publicly. And so people actually withdraw their ads if they are indecent or promote dangerous activities or something like that. But apart from that, there's not much they can do. And this means for general advertising, there is neither an authority nor any self-regulatory body in Germany. But of course, that doesn't mean that you get away with misleading or deceptive ads, for example, because German competitors and associations are not only vigilant and send out warning letters, but they actually take you to court if they don't like what you're doing and if you don't comply with a cease and desist request. So, this might be owed to the fact that I've said this before. In every German, there's little policemen. So they really do. And this has worked so well in Germany that several attempts to establish an authority have actually failed in the past. And one reason might be that not only do the claimants get their lawyers' fees reimbursed, but also in case of a violation of a cease and desist declaration that has been issued, they also get a contractual penalty, which is in there, of a few thousand euros for each violation. So it's become quite a real business, actually, a real business model for some shady lawyers and the associations behind them. So this has quite worked quite well in the past and kept the market clean, I must say. And only in very few fields of alcohol and tobacco, for instance, industry associations have issued their industry codes. But here again, they can only be enforced on a contractual basis. That means only against the members.
I see.
So this is the background which we are working with here, and so clear rules. Actually, those rules for unfair competition or unfair trade practice, they are based on an EU directive and the unfair trade practices directive, and so they apply in all member states. And so there are no special rules for online advertising actually in this code. However, there are a few things that I would like to mention, unless you have some questions to ask now, but I can just mention a couple of things that operators of websites, for example, need to know. I don't know whether that fits in here now. No,
that's perfect. Right. I was going to say, sort of, you've given us some of the taste of the self-regulatory environment. I was going to say, so what are the sort of, rules of the online advertising space that people should know about, and those dynamics?
Yeah, once you advertise online, and that's basically done on a website or in little ads and in other websites, the website operators, they need to have an imprint in Germany. So that is something people from abroad don't really know. But when you look at it on German websites, you'll see them all over. And they need to display and disclose their full name or the company name, and the contact details of the website operator, including an email address or a phone number, for example. And if online contracts are offered through the website, a hyperlink to the European online dispute resolution platform on the website and in the standard terms must be provided, even if the company does not participate in any ADR proceedings here. And even further, and that is a German rule, if a company has more than 10 employees in the past year, additional information on whether or not the company actually participates in ADR proceedings must be offered. It's just the information that you need to offer. You can say you don't participate, but it has to be there. And then the last but not least, I don't really want to go into GDPR issues here, but if any kind of personal information, personal data is being collected, and be it via cookies or somehow else on the website, privacy policy needs to be provided and easily accessible. And that's pretty important because, as I said, the Germans are watching and they'll take you to court even if there's no personal interest behind that. No? And then another interesting issue here is the recent geo-blocking regulation that came into force last year. It's a European Union regulation to avoid discrimination within the EU. An online trader shall not block or limit a customer's access to the trader's online interface, for example, based on customer's nationality, their place of residence, or place of establishment. And also, a trader shall not redirect a customer to a version of the trader's online interface that is different from the online interface to which the customer initially sought access. So, for example, if you want to try to access Google Spain from Germany, you immediately are being directed to the German Google.de page, and that shouldn't happen anymore. And yeah, that's basically what you need to know. Well, in a nutshell, for online advertisers. But of course, the specific rules are there. And now you're going to ask me about keyword advertising. Is that right?
No, well, I actually want to reserve that one, and I want to ask about some influencer advertising too. But before I do, let me just round out the rest of our panel and go to Ricardo,
Sure.
and then we can come back to some of that too. Ricardo, welcome. Last but certainly not least, if you could you set the scene for us in Venezuela and welcome.
Well, first thing is that as you've been seeing or watching me, I've been jumping from one place to the other because we have a few technical problems. So that's the conclusion. That's my main advice to the audience. In Venezuela, improvisation is the rule. It sounds embarrassing, but it is what it is. You have to be aware that in spite of we having a strong set, or at least what appears to be a coherent set of regulation in terms of advertising in general and online advertising in particular, the fact is that since this was not very well planned, it was not part of a political agenda to put together a set of legislation ruling on relevant topics covering the future of advertising. We have to dig. We have to, every time we have an issue to review, we have to start jumping from the Constitution of the Republic back to specific legislation ruling on mass media, going back then to specific topics covering, for instance, pharmaceuticals or children advertising. So that makes us sort of like wizards in trying to make the miracle of finding or providing a coherent response to our clients. So to one point, we have a comprehensive set of regulations. The point is that they are not put together in a coherent way. Then I have to mention, because it's part of our history, that self-regulation used to be an important part for the advertising industry. We took the leadership for years in comparison with the region, making using self-regulation a smart solution to avoid excessive control of content from the regulators. Unfortunately, that situation no longer applies. It has a lesser weight from our day by day operations. The government took the lead, a regional lead, at the beginning of this century, passing the first legislation on Latin America ruling on social responsibility for mass media, covering expressly digital media. So that gives you a hint of that there is a lot of sensitive issues that are covered by that set of regulation. In addition, that we were pioneers back in the 1980s, being the first country in Latin America that implemented a full banning for advertising on tobacco and the alcohol industry. So we've been jumping back and forth in terms of what's the agenda for the government, and it gives the advertising industry a lot of headaches, and it's difficult to project what is going to happen on the short term. Obviously, no one can avoid the political tension that exists between the central government and even some major social media platform, and that could somehow negatively impact any planification you may have as a brand owner in terms of your piece of content might not be aired at the end because there was censorship on a specific program that was going to be aired on YouTube or on Twitter or on a live Instagram. So in spite of the fact that the industry remained very careful, trying to get away from the strict regulation on certain topics, in recent years we moved from total banning on alcohol to tobacco, and now to gambling. Pharmaceutical, other than OTC products, are also banned. But then we start to see some flexibility that I'm sure we will have some time to discuss later on, where in spite of this complete banning, then you start seeing, especially on online marketing and advertising, a lot of content showing or offering products that are, according to the law, are not supposed to be aired, are not supposed to be advertised. So it's like you have to take a conservative approach and play on a day-by-day basis, knowing that it appears to be a big window of opportunity. But in the meantime, I totally believe that a new set of regulations is about to be implemented in the short term, because there's too much flexibility nowadays, which might be seen as a good thing in terms of investment instead of stimulation for foreign investment, for trading in the marketplace. But it seems that we have gotten to the point that consumer needs to be part also back into the conversation.
That was a really interesting recap. I like how you carried your analogy of needing to be just all the way through. That little piece, that little your ending remark there, I think is for me a top takeaway, right? Just in terms of a highly fluid situation. Lots to come, lots to be mindful of, and so I think that's really good advice and counsel, both literally and figuratively, for everybody on this. Would love to at some point hear a little bit more about about what you think the form of that, whether it's a regulation or whatnot, looks like. We have about 10 minutes. I'm usually late to things, but I feel like I've done a reasonably good job on time here. So that's a win for me already. So I want to open up to a little bit of a group discussion here. One of the topics that I want to flag is influencer marketing. It was a theme that came out in all my conversations and my notes with all of you. So maybe in a way that kind of gives everybody an opportunity to comment. Going sort of around the horn here, could you each give one or two sentences about what's the most important thing for advertisers and marketers to know about influencer marketing in your region, and then if you have a thought too about or if you want to comment on the things that your colleagues are saying, that would be great too. Handi, why don't you start again?
Sure. Actually, I have briefly mentioned before, we don't have any specific rules about influencer marketing, but the Ministry of Trade back in 2017 published an announcement on their website warning the consumers about this influencer marketing. Actually, what the ministry told to consumers in this announcement is that they must be aware about this content, and because normally there should be a clear statement showing the relation between the influencer and the brand owner, but if not, this still may be an advertorial content. So the consumers must be aware about such a situation, and they must be careful while following the advices of this influencer. So this is actually a little strange, because instead of publishing guidelines for the influencers, and instead of saying them that you must use these disclosures, you must just use some keywords showing the relation between you and the brand owner, here the ministry warns the consumers to be aware about such relations. So they prefer this way. So what should the advertisers must follow in Turkey if they would work with the influencers? It is actually mostly related with the health claims, as I previously mentioned. So tobacco, alcohol, and drugs, and gambling, they are all prohibited in Turkey, but health claims are quite important for the ministry. They never miss any claim about health claims, and the influencers, at least in Turkey, they are mostly used for health-related claims. Like they are, in most of the cases, they are promoting food supplements, which make them feel healthy, fit, and now they are protecting them against this coronavirus as well. So this is a quite important fact in Turkey. So brand owners whose products may be advertised with health claims, they must be very careful in Turkey.
Great. Canoe, looking at you next. We did talk about the law. Any other little details to add?
For me, no.
Okay.
Mm-hmm.
Canoe, what about you?
So basically, like I said, the most important thing is that you have to show that the post is of commercial nature. So disclosure labels that are very important. So that's what the draft guidelines, which has been issued by the Advertising Standard Council of India, that it also places importance on that, and they have actually chosen specific disclosure labels that are to be used. And so, other than that, the most important thing is to demarcate that this is not a user generated content. This is a commercial. This is a commercial post, and you have to show the commercial intent. So that's the most important thing. And based on that, the once the guidelines for influencer marketing they're finalized by the Advertising Standard Council of India, and that's going to be happened by 31st of March. Then the things will become more clearer, and so that's the scene in India as of now.
Great. Maria?
Well, I would say we don't have any guidelines from the Federal Anti-Monopoly Service regarding influencers. The recent cases that were considered by them were relating to actually alcohol advertising by such by bloggers. So they were considered as responsible for such kind of advertising. And recently we had a case which is pending actually now. It's more like a provocative advertising of one of the music groups, and made for a bank in Russia. And interesting that the bank was held liable for this piece of advertising. But generally, I would recommend thinking of some kind of safeguards in the contractual relations with bloggers, saying that they are responsible for who is responsible for what in making the content, and distributing the responsibility on them, at least for following the rules of advertising laws, and maybe IP protection as well, so that they don't infringe others' IP rights. So that's, I would say, for now, it's the most crucial for the market.
Okay, thanks. Soren?
Well, again, there's no special law for or against influencers here, so they have to comply with the rules. And then one of the rules in Germany is, of course, disclosure, and that's the hot topic still. And we have had many cases where the influencer tried to defend them or herself by saying, I bought the product myself and I just liked it. And of course, then the court said, well, if you have a five-digit number of followers, this is still a business and it's yours, even if it's not the sponsor's business or the business of the sponsored product, which is not in fact sponsored. Then it's still the business of the influencer. So the courts are divided, and we have not had a Supreme Court decision yet, and on the question whether if the product was bought by the influencer her or himself, whether this should be disclosed. So I strongly advise to, yes, do disclose it, or they should disclose anytime they promote a product or a service of another company. And now the other question is how to do this. And we have heard sponsored by or hashtag ad or something is sufficient in other countries. It's not in Germany. Although many people, or almost everyone in Germany, would understand it, the judges, who are a bit older probably, they don't, or they don't want to understand. So we have had rulings recently still where an influencer actually disclosed that it was a commercial, an advertisement by sponsored by or ad, hashtag ad, and that wasn't considered to be sufficient. So they need to do it in German. In the German language, use the word Werbung or Anzeige, which is the typical disclosure for an advertisement.
Great. Finally, Ricardo, you talked a little bit about it too, but another sentence or two if there is one.
Sure. One rule is that we cannot forget that offline advertising applies. The principles rule in offline advertising also applies to online advertising, because our specific law on that covers social, television, radio, and digital media. So that's important to keep in mind. Number two, everything that that is related with influencer, the rule says that it has to be a full disclosure so that people understand and know that there is a relationship, sponsorship relationship between the individual and a certain brand impulsing the product. Perhaps one of the in practical terms, it happened but with a double standard. We have a local situation because of the crisis that has been affecting the country for many years now. More than 6 million of Venezuelans has left the country, including well-known celebrities, entertainers who are now sponsoring local brands. So normally they don't comply with these regulations. So we have like a double standards. Those who are influencers, celebrities, doing business locally, living in Venezuela, which are more concerned about being sanctioned by the authorities. So they try to comply, with the regulations. And then you have a vast number of individuals doing business for the Venezuelan community who are ignoring those regulations. So my guess is that we're going to see new regulations covering or governing on these matters in the short term, because definitely influencer marketing has become a standard tool for the local market nowadays.
Right. Interesting. Very interesting dichotomy between those two. We've got about 3 minutes. I'd like to get through 2 more questions. So maybe we do it as a speed round. So the first question is, 1 year from today, what is the hot online advertising topic we'll be talking about? Handi.
Well, actually, Turkey is usually following EU in this regard. So, currently, I don't expect any new developments, actually. I hope that COVID-19 will not be still the hot topic, actually, for the following 1 year. But maybe this disclosure issues can be a hot topic. Sweepstakes, also, organized by influencers. They are also currently being discussed by the National Lottery Organization. So we may expect these discussions. And also, if there will be a hot topic in Europe, we will be discussing it.
Great. Canoe.
So I think because of the pandemic, misleading advertisement is one of the hot topics right now. I think that's going to continue for some time. And again, influencer marketing, that's going to be a hot topic because new guidelines are going to come. Apart from that, data localization, that's another topic I think would be a hot topic in India.
Yeah, we could probably have a whole separate another webinar on that.
Yes.
Maria.
I think for Russia, the more like going more and more important things are like ethics in advertising. So it's likely that there will be more disputes regarding borderline ads in general in offline and online as well. So apart from influencers, of course, who are getting more and more control.
Great. Soren?
Well, there will be on EU level, there will be the Digital Services Act that is being planned now and coming into force probably end of the year or next year, if agreed upon finally. And that will deal a lot. It will affect all advertisers, of course, but mostly affect online advertisers because it deals about, or it's about disclosure requirements, for example, as to whether or how consumer evaluations are being checked for authenticity, which is quite a deal, and disclose parameters for ranking and search results, which is interesting. And if they have to disclose whether it's influenced by payments or other benefits like discounts on the next purchase. And then there are consumer reviews. And if a seller states, for example, that a consumer review is actually from a real consumer with authentic experience, then they have to establish a mechanism on how to confirm that this is really authentic. And then there will be a prohibition to have issued or use false customer reviews or recommendations, which would also include the incentive to likes. So I think this is something we'll be talking about and watching, and how this affects actually the behavior of the advertisers.
Great. Ricardo.
Well, I would say that definitely a new set of specific and updated rules for digital market is to be expected. A new e-commerce set of rules, but ours is back to the 90s, so it's needed an updated version of a legislation on e-commerce. Definitely transparency on the use of personal data. We're having big headaches because seeing big corporation, multinational corporation complying with international standards, while local entities or small corporations from other countries not respecting the international standards. So that definitely is should be part of the agenda. And finally, a total review on the legislation concerning consumer protection. We have gone for having an excellent set of legislation ruling consumer protection to a point where basically isolated norms are found on a specific legislation. So if I'm to bet, I'm hoping to win. I'm on this group. These are my cards for next year.
All good cards. That's wonderful to hear. We are getting very close, so let me just see. Let me look through the audience questions. We did have there was one question about the ICC advertising and marketing code implementation, particularly in Russia. So, Maria, can I look? Is that putting you on the spot for that question? Is that something you want to take a moment to answer?
Yes, sure. Well, the ICC code is voluntarily adopted by some of the associations, and they follow the guidelines of that code, especially, for instance, AAPM, Association of International Pharmaceutical Manufacturers, and some other associations that try to develop the self-regulation in Russia. So yes, it's being implemented, but not on the level of the state, and it's more like associations of different market players that implement them.
Great. Thank you. Well, the final question that I was going to ask, but we're short on time, was where is the first place you are going to travel to post-COVID? But it is currently in the 20s and very windy where I am in Washington. So, Ricardo, your blue skies in the background, look pretty inviting to me. So, someplace warm would probably be my answer. Let me take the time to thank all of our wonderful panelists. I thought this was incredibly useful. I hope that our audience members did too. I really appreciate all of the insights that you have shared with us, and hope we have an opportunity to do it again soon, maybe even in person, which would be a wonderful experience. So my thanks again to all of you for joining us, and to all the panelists.
Thank you very much.
Thank you.
Thank you.
Thank you.
Bye-bye.
Bye-bye.